So good morning, everyone. I'm going to be talking about a paper we're working on. So myself and Professor Malcolm Langford at University of Oslo. It's called Fait, Accompli, and it's about predicting the outcome of investment treaty negotiations. So I just thought I'd start off with a little bit of background. So we're working in the field of international investment law, and this is quite an odd field. There's about 3,000, it's a system based on about 3,400 bilateral investment treaties. And what they do is, very basically, if an investor from one state invests in another state of the treaty, and the host state of that investment sort of screws up or does something illegal in terms of the treaty, the investor can seek arbitration against the first state. It's a system that originates in the 1960s. It gains a lot of traction in the 1990s and completely explodes in the 2000s and 2010s. And it contains relatively few cases, but most of them are quite high value. So this is sort of the background we're working in. There's been quite a lot of work in this space about what actually impacts the negotiations themselves. So Elkins et al. Has argued that the system itself is promoted and driven by developed states against less developed states. And they found that developing states that have IMF or World Bank debt relief programs are significantly more likely to sign these treaties. Ali and Painhard has observed that various forms of power, so both military power, but particularly economical power and resource power, has a significant impact on how these treaties are negotiated. Wolfgang Alschner and Skorsky looked a lot into how reproduction and replication of language works in this field. So just to give you a little bit of context there, we have 3,400 treaties. Some of them are exactly the same. A lot of them have copy and paste, and here I actually mean literal copy and paste. In general, they're very similar. They're not necessarily identical, and in terms of international law, they stand on their own. They are treaties. But there's a lot of replication and a lot of inspiration going on. But there's also differences between them. So Paulson has argued that developing and emerging states tended to not actually negotiate international investment agreements at all, simply signing what was put in front of them with perhaps limited understanding of their economic consequences. Later research has also shown that treaties are signed and negotiated perhaps at the incentives of diplomats themselves. Basically, Paulson and Eisbeth argue that diplomats like to sign agreements. They like the process around it, and they have some personal benefits from it. And then finally, in a paper that hasn't been published yet, was published on SSRN, Berg and Stiansen also looked at how bureaucratic capacity impacts the negotiations. And last one, I just want to say a few words about. These treaties are, for most states, of perhaps less interest. And one of the reasons for this is, first of all, they're bilateral. And the second is that most treaties haven't ever been used. So most states perhaps have gotten sued in this system once, twice. Some, of course, countries like Argentina, Spain, Egypt, some of these are sued a lot. So they have a lot more bureaucratic capacity in this area. But for most states, this is sort of a sign and forget kind of thing. So the purpose of our paper is actually trying to predict the negotiation outcome of treaties signed after 2015 using machine learning on treaties signed before 2015. Now, to do this, we study about 40,000 clauses in 3,400 bilateral investment treaties, so using the full text of the clauses. So all this data comes from a wonderful project called EDIT, the Electronic Database of Investment Treaties, which was created at the World Trade Institute. It's a fabulous database, well-structured in XML, machine translated into English for those treaties that are not. And it's a wonderful data source if you want to do empirical studies on these treaties. So the first thing we had to do was establish some ground truths. So what we try to figure out is who actually writes each individual clause. Now, of course, the authors don't sign their clauses. Unfortunately, that would have been very nice. So we actually have real ground truths for this. But what we've done is using a combination of topic modeling, manual review, and quite a few text comparison algorithms, we were able to take the combination of the text and the metadata on each of the clauses in the treaties and sort of build these family histories of them, trying to figure out who actually wrote the clause. And it turned out that was actually possible. This is partly because states tend to reuse their clauses, and their counterparts tend to not reuse clauses that are not theirs necessarily in older treaties. So this was a fairly big work sort of establishing the ground truths. And using this data, we're sort of able to build up our training set. Now, for transparency, there's a couple of things that's quite important before we start talking about the results, and that's of course caveats. So this paper is full of caveats, basically. The first one, which is related to our previous slide, is that when we try to basically have the computer guess who the real author is, what we're actually having it guess is we're having it guess who we think the real author is. Because, as I said, they don't actually sign their clauses. So the ground truths here are, of course, our qualified guesses with a lot of both manual validation and computer validation. But of course, it could be entirely wrong. So when we talk about results in just a moment, have that in mind, that this is simply seeing how well the model fits to our guesses. Now, our guesses do coincide well with previous literature, so I don't think we're entirely off, but it's worth having in mind. Another thing, of course, is that there are technical issues here. Everything in machine learning is, of course, probabilistic. There's also some issues sometimes with the data itself. In most cases, the data that we have is excellent. It's well structured. It's without any issues or problems, but there's always a scan error, or there might be some other minor issues with the data. Also, because some of the treaties that are not in English are machine translated, that's also possibly a slight issue. But continuing, so the training set is, as I said, it's basically every treaty and every clause from the beginning of the system, which is in the late 50s, and until 2015. And then we test it on clauses that are from 2015 until 2020. And what we train it with is basically three things. So we have the first treaty party and the second treaty party. This is just random. There's no significance in the order of these. And then it's the clause type. So we separate the clauses into 43 different legal categories. And then we have our ground truth, which is the originator. So this is the party we believe is the author of the clause. So this is our training material. So we put all this into a deep learning model. We use something called Ludwig, which is basically a front end for PyTorch, which is a wonderful little tool which helps us do research very nicely and quickly, but still gaining all sort of the advantages of the leading open source technologies. The results are quite fascinating. So we tested about 1,303 clauses across 43 different categories. And our results are, well, silly. We get 96.8% accuracy. And just to point out, the model has no idea about these 1,303 clauses. They're entirely kept out of both the training and the validation process. So basically, we create the model and then we test it afterwards on these clauses. So in my personal opinion, this is a little bit too good to be true. Based on the number of clauses and the number of size of the training material, we shouldn't really be getting these kinds of results. So we started looking into alternate explanations. And our thought is that it's not really the model that is terribly good. It is that investment law in itself is remarkably predictable. So we started looking at various factors that could affect this. And we found that GDP actually gives us a real hint. So using the family trees, we went through and calculated the GDP of all the parties in every single negotiation. And what it turned out was that basically the state with the highest GDP actually wins or gets their language in 97% of the time, which is, well, quite ridiculous, to be honest. And I just want to point out, the model has no idea about this. It simply gets these 3 variables or 4 variables with the ground truth. So we actually find that this fits quite well into the previous theories. There's also been studies in previous theories about GDP, where both Ali and Peinhardt, Alshner and Paulson, they all find this sort of idea that power, and especially then economic power and stature, has a quite significant effect on outcomes. Now, most of these papers have looked at one small part. Well, one small part of the treaty, for example, the fair and equitable treatment clause or the conflict resolution clauses. But what we actually found was across the board, our algorithm shows that all of the different sort of legal parts of a treaty are almost equally predictable. And most of them fall into this sort of GDP hole. It also makes a lot of sense if you think about the bureaucratic capacity. Richer countries will typically have a higher bureaucratic capacity. They will typically have more knowledge. They will have more people usually working on it than countries of less economic stature. And it also fits quite well with the idea of diplomats' personal incentives. Because for a lot of countries, negotiating the detailed language might not necessarily be as interesting as getting the treaties through, which would quite easily incentivize just using the language that sort of is apparently is going to get in anyway. So that's the short version of our presentation. We find it really surprising that we were able to predict this in such immense accuracy. And it also leads to this a little bit of an awkward question. If we're able to predict quite with almost certainty how a treaty is going to look like, not just on the sort of grand scale, but actually on the details. So we can look at each individual clause in a treaty, and we can pretty much guess which party's language is going to go through. Now, this, because of the methodology here, there's one additional little caveat here. While we're able to see sort of whose language it is, there might be minor details and changes in the language, which our model doesn't necessarily pick up on. And of course, for legal questions, that has a significance. Devil is usually in law in the details. But even so, it comes quite clear that perhaps negotiations, at least for the outcomes, might not matter, but they might have a significant impact on other areas, such as relations between the states and things like that. So I think with that, I will allow for some, ask for some questions or comments. Thank you very much for your attention.
Thank you, Runa. Do you have any questions? Let me make sure I monitor the chat as well. Yeah, I think while people are thinking, I actually do have one question, if you don't mind. It's about the caveat that you mentioned at the end, which is to do with like some minor changes in the clauses. So I might have missed this in your talk, but I think when in trying to get the ground truth labels, you went through a process to use some text algorithms, topic modeling to figure out who wrote. I would imagine it's like a paragraph, right? And
Yep.
I think what I might be worried about is perhaps in the negotiation process, a clause that begins from a country like the US, maybe 99% of the words comes from the US, but because of the negotiation process, the other state manages to change one word, and that one word is like, instead of 5 million, it's 20 million, right? I wonder if then, how the algorithm you develop to find the ground truth would deal with that kind of situation.
So there's a couple of different mechanisms. So first of all, that is a very real problem where we have limited ability to find these sort of very small details. But what we luckily have, because the amount of treaties is quite large, what we see is that when we go back in time, a lot of these clauses become very clear. They're identical, basically. So if we go back in time, the sort of, if you look at Jacquard distance, for example, or cosine distance, you can go literally back 20 years and there's no changes in some of these clauses. So doing that, we're able to quite effectively sort of not miss these changes. The other thing we do, which I didn't quite cover because of time constraints, before we actually feed this sort of main model, there's some filtering process where we go through and run Jacquard distance, cosine distance, check for exact matches, and also do, there's a third machine-based algorithm to validate that the sort of the previous entries are more or less exactly the same. So basically we filtered out where we can see that the topic modeling, for example, originally has been too generous. That does improve the results somewhat, but primarily I would say that the main reason we can sort of quite confidently say that there hasn't been at least too many significant changes is the volume. Because we have, for at least most of the clauses, a fairly decent volume of text, which is remarkably similar, which does increase the confidence in sort of building these ground truths. But of course, I mean, it's not perfect, and we don't intend it to be either, because the idea here more is sort of seeing this larger patterns. But of course, if you go into any sort of individual ones, you will find that there might be minor, I would say not mistakes, but differences between the clauses.
Right, thank you. I guess the question was motivated from, if we are sort of thinking as lawyers and trying to negotiate, I would imagine that if I was a small state and I was negotiating against like a huge, powerful state, and if I managed to change one word in the clause that was suggested to me, I would take that as like a huge win, an absolute victory. And because we are correlating this, whose language is used to the who wins the negotiation in this case. So I wonder if there's a possibility for maybe a kind of an extra label where instead of just saying, oh, it's the USA which wrote the clause and so they won, is there like a draw outcome or like some kind of a more nuanced outcome that you could incorporate?
Yeah, I think that would be actually very interesting to do. And I think it's a great point, but also I think it's a great point in terms of what the practical sort of outcome of this article is. Because I think what you're addressing there is exactly what I would sort of as a policy recommendation recommend. Because what we can at least see is that if the weaker party, they basically have no shot at getting their version of the sort of big treaty in. That's a lost cause. But if they focus their attention on the minor details, they might actually have a pretty good shot at that, at least theoretically. They might get some minor changes in, which may have a significant legal or political advantage for the less wealthy states. So I think both sort of in terms of the outcome, but also I really like the idea of granulating the outcome results. Perhaps looking at first of all, perhaps doing a more doctrinal study of some of these paths, but also granulating in terms of, okay, but how different are these sort of versions? How much change was it from the previous version? That could be a very interesting stat to put in. So I appreciate that comment.
Thank you. Are there any more questions, comments from the audience? I actually have a few more, but I don't want to dictate the discussion here on the abuse of power. Okay, if not, then maybe one last one. I guess flowing from what you just said, Runa, I think the data is that you have seems to be very promising. It probably can be used to kind of look at the textual changes, right, as you've described. So I will be interested to know things like, in cases where small states are up against big states, how often have they managed to change individual words in the clauses, and what kind of words those would be? Are they things like dollars, or is it just for the less relevant stuff like the boilerplates and things like that? I mean, I'm not a specialist in international law, but I guess that might be of general interest.
Yeah, that would be quite fascinating to run, and we have the data set to do it. So looking at sort of the details of what has changed, and perhaps creating some, I would say, statistics or reports on that, I think also could really benefit doctrinal scholars who try to look at this, because one of the issues with this system, of course, is that the amount of treaties is so large. I mean, there's 3,400 treaties. It's almost impossible for a human to get that overview. But of course, aggregating these results and creating these sort of lists, or, oh, this is an interesting sort of chain of events that should be looked at. I generally think that's one of the great things about empirical research in law, is that we can help out doctrinal researchers to find where the actual interesting stuff is, so that they can spend time and go in and look in detail far beyond what we can do with our computers.
I completely agree with that. Thank you. Just one last request, for the benefit of the colleagues here, would you mind posting the link to the database, the edit database that you mentioned? People can take a look at it.
Yeah. I'll post it in the chat.
All right, thank you.